Hi folks, this is Kip from Malik and Malik. Today I'm going to be talking about a Supreme Court case. It's State XRL Block versus the Industrial Commission. And in the notes of this YouTube video, I'll have the link to this actual case so you can download and read yourself if you want to. In this case, the relevance of this case is it's a loss of use award, or this person's pursuing a loss of use award. It's another form of compensation. So remember, there's temporary total disability. That's the most common form of compensation, and then you have your permanent partial disability awards. You have a permanent total disability. You have your VSSRs, and you have various other forms of comp, and then loss of use awards. It's another form of comp. And so you could file loss of use when you actually, the person, unfortunately, their body part is amputated. Alternatively, if they've lost, for all practical purposes, the function of that body part, then they could also file for a loss of use of that body part. And it's paid out of for the actual way that these things are paid out, you could actually look at the workers' comp rate chart, and I may paste that into the case notes as well. But also you could look into the 4123.57b, and again, I'll put that in the notes so you could click on that and read it, and it'll say, hey, how much weeks you get for this type of injury. And so this case, it's again this Block versus the Industrial Commission. What happened here was this guy, I don't know, it's kind of a crazy fact pattern. So this individual in December of 2012 fell 35 feet from a roof onto the concrete below, and then he ended up fracturing his distal radius. He had a non-union of his right wrist and then myofasciitis. So, I mean, the guy fell 35 feet and he broke, he got a really bad fracture of his right wrist, but man, that could have been a lot worse. He could have been paralyzed, or he could have fallen on his head and had some kind of major brain damage. So not that it's awesome to get a right wrist fracture, but I don't know, if you're falling 35 feet, that's not the worst thing that could have happened to this guy. So anyway, so this is 2012, and this case is from 2023. So this guy, he ended up getting a number of surgeries for his hand, wrist, right hand, right wrist, and then he ended up getting physical therapy and all these things. And eventually, he or his attorney decided to pursue this loss of use of the right hand. And again, remember, with loss of use, you can pursue that even if the body part has not been, like, you haven't lost it, it hasn't been amputated. And so this guy filed it. His doctor, which was this named Dr. George, he examined his hand, found there's his left wrist, he could lift a lot more than his right. So his left wrist, he could lift 26 pounds, I believe, and the left he could lift 26, and the right he could lift 11, or vice versa. If he's pursuing right wrist, presumably he has less grip strength in his right, I would assume, but nevertheless. So and this Dr. George, who was his provider examining for this loss of use award, was basically said he's not capable of doing a construction or roofing job, and therefore he's lost the use of his right hand. So first off, his medical provider is Dr. George. That's the wrong standard. So it's for, have you lost, for all practical purposes, you lost the function of that body part, not are you able to do the job that you had before you got injured. So different standard, different application doesn't apply to loss of use awards. So then the BWC and the Industrial Commission, they had him examined by this Dr. Pellegrino. And Dr. Pellegrino, here's the thing, I've done another video, and you'll run into these names, and I don't really have an opinion one way or the other of this Dr. Pellegrino, but you'll run into the BWC, the IC, they hire, you'll see the same doctors over and over again. So is this doctor biased? He may be. Haven't really looked into it with this particular doctor, but it's a possibility. Particularly if these doctors are doing these exams over and over again, if they're always allowing things, then the BWC, the tendency is that they might not be hired again. And you'll see that kind of pattern with these physical doctors, less so with some of these psych doctors, particularly if it's a psych doctor in a different part of Ohio that is not often tapped. And those doctors, you'll see, surprisingly, they'll actually support things sometimes. But so anyways, he does this, he's examined by this Dr. Pellegrino, does this light palpitation of his hand, noted that he had pain, exaggerated withdrawal response when palpitating his hand. He had his individual fingers and right thumb within normal limits. His muscle strength testing was 5 out of 5. He was able to make this okay sign with normal strength, and his neurological functions were fine. But in the opinion of this Dr. Pellegrino was he has some issues, but not to the point where he has lost use of his right hand for all practical purposes. So 2 different opinions. Dr. George kind of using the wrong standard, but I think in this case he ended up, his attorney ended up getting a rebuttal from Dr. George. But nevertheless, Dr. George is saying he has. Dr. Pellegrino is saying he has not. So this was pursued, filed with the BWC. It goes through DHO. DHO granted it, and then it was appealed, and then the SHO denied. And the SHO was basically stating, hey, there's no evidence presented that the functional limitations of the use of the right hand are permanent, and he retains some functions of the hand, but he's not lost the use of his hand for all practical purposes. And then in the appeal to the 10th District, and the 10th District, 10th District Court of Appeals in Ohio, in Central Ohio, Franklin County to be exact, found the reports of Dr. George and Dr. Pellegrino to be some evidence supporting the Commission's decisions, and they denied Block's appeal. So Block appealed to the 10th District, and then the 10th District, they ruled for the Commission. So then Block appealed again to the Supreme Court, and that's how we get this decision. And then the Supreme Court, they come up with they give out their rationale, and essentially they, surprise alert, they agree with the 10th District, who also agreed with the Industrial Commission. And again, they say, they talk about this permanency. An individual can pursue a scheduled loss when the body part is amputated or the loss of use of the body part is permanent to the same effect as if the body part has been physically removed. So for instance, for all practical intents and purposes, it's non-functional, it's not useful. But they talk about the permanency in the context of different forms of comp. So in temporary total disability compensation, permanency, and this would also be permanent total disability, means the condition will never improve to the point where the claimant can resume his former position of employment. PPD comp, so this permanent partial disability compensation, that's that C92 award. They basically say it's more like a damages award or pain and suffering in the context of a permanent personal injury case. And then the scheduled loss awards, permanency represents a level above which a claimant's condition will never improve. So you can't do any more treatment, you can't do any more surgery, you can't do any more physical therapy, anything else. It's not going to improve. That's it. That's the permanency. The function that this person has is not going to go beyond this point. And then the level of the condition will go back to if the condition temporarily worsens. So let's say the condition worsens, and you do your surgery and treatment. It's not going to go above that point. So it might get worse, but it's not going to go above this point. So you're not going to get more functionality. So that's what permanency means in the context of a scheduled loss award. And then in Block's case, the Supreme Court says his loss to use expert Dr. George did not offer proof that Block's condition had reached a level above which it will never improve. So the Industrial Commission and the Supreme Court are basically saying, hey, this guy, maybe you get more surgery, physical therapy, and then maybe it'll improve. And then they finally say the Industrial Commission did not abuse its discretion, finding that Block had failed to present proof of a permanent loss of use of his right hand. And they further state the Commission expressed that all proof on file was reviewed and considered. And then they're in responding to the injured worker's objection to one of the decisions of the district. The Industrial Commission is not required to show what specific evidence it relied upon to reach its conclusion. So all the Industrial Commission has to say is, hey, I've looked at the file, I've reviewed and considered all the evidence. They don't have to say, well, actually I looked in this document and on page 5, paragraph 6, this line here, that's what I'm relying upon. They don't have to do that. They just have to say the information, the claim file has been, the proof on file has been reviewed and considered, and they've made the decision upon some evidence. So the takeaway for you, and these are kind of some of my editorial thoughts with this is, again, you can pursue a scheduled loss award even when your body part is not amputated, and then again the loss of functionality has to be permanent, and it's not, and it has to be for all practices and lost the function of that body part for all practical purposes, not you've lost use of the body part to do some particular job that you used to do. So it can't be, I injured my hand and I used to paint walls and now I can't paint walls. That's not the standard. Or I used to be able to drive trucks and now I can't drive trucks. You cannot rely upon that to support the position that you've lost the function of that body part. Okay, so it's not, I can't do this or that specific job because of the issues of the impacted body part. The other big takeaway, and it's not really addressed in this case, but it's kind of a thing that is there. It's this issue of who's deciding your case. So if you recall, when I went through the procedural pathway of this case, the DHO actually granted this individual's loss of use award for the hand. So the DHO granted it. Somebody appealed, either the employer or the Industrial Commission. It went to the SHO, and the SHO denied. Has anything changed? I don't know, but if nothing else has changed, then the big change in that instance was the hearing officer changed. It was a different hearing officer. So the DHO, you're going to have one hearing officer. SHO, you're going to have a completely different hearing officer. And that's that human factor, that the hearing officer, and they can have a huge impact on the outcome of a hearing, either positive or negative. You can't choose your hearing officers. Some hearing officers lean more one way, some hearing officers lean more another way, some hearing officers lean down the middle in one way, and other hearing officers down the middle and the other way. But the injured worker cannot control that, and then the Supreme Court is not addressing or analyzing the personal leanings of that hearing officer. So maybe that should be a part of these things. I don't know how they would do that. One way that they might do it is if somebody did like a Freedom of Information Act request to the Industrial Commission and requested, the outcomes of every hearing officer. Did they allow things? Did they deny things? For scheduled loss awards, for instance, how often would they allow things or find that the person's had a scheduled loss versus how often they did not? If you could show maybe that the percentage with this particular hearing officer, 80% of the time they'll deny a scheduled loss award, then maybe you'll be able to say prove bias. Maybe not though. Maybe they would still say, they would still say, well, that's just coincidental. But that's a big part of these decisions, and you kind of see it in play in this again because they allowed a DHO and they denied an SHO, and the Supreme Court and they're just going, hey, did they rely upon some evidence? The only other way you could defeat that is if the medical evidence of, say, Dr. Pellegrino, if his positions were so internally inconsistent, then maybe you could throw out his report and then get another bite at the apple. But if there's no major errors that were in his report if there was no, if you can't show that, if you can't show that he didn't have access to all the information, and if you can't show that he was internally inconsistent, then it's, even if you don't like it, even if it's super biased, even if this is one of those doctors who, 9 times out of 10 he's gonna write a report that denies what the injured worker wants, that doesn't matter. It's some evidence. The hearing officer relied upon some evidence, and the Supreme Court is not going to disturb that the fact finding of the Industrial Commission. So it's pretty, it can be pretty brutal, and as you can see with this individual, he didn't get the loss of use award, and that could be it can be a reasonable amount of compensation, and particularly if this guy cannot, I don't know, he was working on roofs, presumably he can't work on roofs anymore, so he did lose out some money. But so that's a loss of use award of a body part, and how that might play out and work out. As I say at the end of all these videos, workers' comp is fairly complicated. Well, it's really complicated in Ohio. So if you have a workers' comp case, don't do this on your own. Consult with a bunch of attorneys. Ask your friends, neighbors, co-workers, doctors, etc. Ask them, hey, who do you use? Who do you recommend as a workers' comp attorney? And then go talk to that attorney or attorneys. Run your situation by them. If they think you need an attorney, they'll let you know. So if you have any questions, concerns, etc. for me, leave the questions in the comments, or email me, or call my office, and then run your fact pattern by me, and we'll discuss it. Thanks for watching this video. This has been Attorney Kip from Alec & Malek. Thank you. Bye.